Welcome everyone to our webinar. I'm just going to allow a minute or two to allow all participants to file in. I'm seeing the participant number go up. So we'll give it about a minute or two to allow everybody to connect and settle in, and then we'll get started. Okay, well, I think our participant count has started to settle down, and it's 9:01 for me here in Vancouver and 12:01 for many others, and some others in between as well. So I think we should get started. So good afternoon or good morning, and welcome to our fourth webinar in the Canadian Trademarks series. My name is Quan Lo, and I am counsel in our trademarks practice here at Smart & Biggar. Together with my colleague, Tierney Deluzio, I will be one of your speakers for today's presentation on distinctly Canadian unique aspects of trademark prosecution in Canada. Now, before we begin with the presentation, I'd like to start with a couple of housekeeping matters. So our formal presentation will last for about 30 minutes or so today, and it will be followed by an open and interactive Q&A session where we will address, or try to address, more specific questions that you may have on our topics today. You're welcome to submit questions anytime during the presentation by typing them into the Q&A panel in Zoom, which can be accessed by clicking on the Q&A button at the bottom of your screen. Please do not type your questions into the chat panel, as those won't come as easily to our attention, although they'll probably make their way over here, but it would be easier, and we'd greatly appreciate if you use the Q&A panel for your questions. We will try to address as many questions as we can in our live session today, which is going to end at 1 o'clock or 10 a.m. for me, or in a follow-up by email after today's session. We will run our whole session first and answer questions afterwards, but please feel free to send in your questions anytime. Today's webinar will be recorded, and following the presentation, we will circulate an email with a replay link. You'll also be able to request a PDF copy of the slides from our presentation today if you wish to have them. At the end of the webinar, a link will pop up to complete a survey. We would really appreciate if you could take a few minutes to complete the survey with your feedback on today's webinar, as well as the topics that you are interested in learning more about. And with that, let's get started with a brief introduction to Smart & Biggar. So here we have our speakers today. That's me on the left and Tierney on the right. And just a very brief comment about Smart & Biggar. I know that many of you are quite familiar with us, and I certainly don't want to take up too much time today talking about our firm or bragging about our firm. We're Canada's leading IP law firm with offices across the country, Vancouver, Calgary, Toronto, Ottawa, and Montreal. We cover all areas of IP, trademarks, obviously, but patents, copyright, litigation, trade secrets, you name it. If it's IP, we have our fingerprints on it, and we're very comfortable and experts in different areas. We've been doing this for over 130 years, so lots of experience, 100+ lawyers, agents, and consultants across the country working to serve you and your clients. And we file thousands of patents and trademarks annually. So we know what we're doing. We have a lot of experience and expertise doing it. And we've had a lot of successes, including at trial in the past 5 to 10 years. So I'll now set the table today for our discussion on trademarks, distinctly Canadian issues. What better place to start for a distinctively Canadian discussion than distinctiveness? So that'll be our first topic. We'll then move on to a discussion about use, and then some comments on goods and services. And after that, we'll move over to prohibited marks, which are a really unique feature of the Canadian trademark system. And with that, I will now turn it over to my colleague Tierney to lead us off with a discussion on distinctiveness. Tierney.
Thanks very much, Quan, and welcome everyone to the webinar today. There we go. So as mentioned, the first topic that we will be covering today is distinctiveness. And I would like to begin with a brief overview of what distinctiveness means in Canada. So Section 2 of the Canadian Trademarks Act defines distinctive as referring to any trademark that actually distinguishes the goods or services in association with which it is used by its owner from the goods or services of others, or that is adapted to so distinguish them. A trademark actually distinguishes by acquiring distinctiveness through use, resulting in distinctiveness in fact. Acquired distinctiveness is something that is gained or earned over time, and it can happen to any trademark and depends on the extent of use, advertising, sales, etc. In contrast, a trademark is adapted to so distinguish when it does not depend on use for its distinctiveness because it is inherently distinctive. Inherent distinctiveness is intrinsic to the actual trademark itself. It's what it is that makes the trademark unique. For example, a mark that is a coined or invented term, or is completely arbitrary and non-distinctive of the associated goods or services. If you're more familiar with patents, it might be compared to novelty, and in the context of copyright, it could be considered analogous to originality. One important principle to remember when considering distinctiveness is that distinctiveness is a spectrum. It is not simply a yes or no question. A trademark does not either have distinctiveness or not. There is a range from 0 to a tiny little bit to what would be considered a weak mark, to your average mark, to the most distinctive mark that you could possibly imagine. Something that's a coined word that doesn't resemble anything like a word in the dictionary. Next slide, please, Kwan. So why is this relevant to today's discussion? And what is it that makes distinctiveness unique in Canada? Well, the distinctiveness of a trademark has always been important in Canadian trademark law. However, unlike many other jurisdictions, the distinctiveness of a trademark was not substantively taken into account during the examination process until Canadian trademark legislation was recently overhauled. Since June 17th, 2019, the Trademarks Office now has the power to object to the registration of an application on the basis that the applied for trademark lacks distinctiveness. The relevant provisions of the Canadian Trademarks Act, as amended, are shown on the slide. Now, almost exactly 3 years since those amendments, practitioners and applicants have learned that Canadian examiners are wielding their new power with enthusiasm. In fact, it has become one of the most controversial aspects of the changes to Canada's trademark law due to the inconsistent manner in which the Trademarks Office has applied the objection and the lack of transparency as to the criteria which examiners are applying in assessing distinctiveness. And to further compound matters, since this is a completely new objection, we don't yet have any jurisprudence setting out what it means for a trademark to be sufficiently distinctive to be registrable. Next slide, please, Kwan. One resource that we do have available to us is the Canadian Trademarks Examination Manual. In the manual, the Trademarks Office has provided some guidance as to the examination of distinctiveness, including examples of trademarks that it considers not to possess any inherent distinctiveness. If an applied for trademark meets one of these criteria, the examiner will almost certainly raise a distinctiveness objection. So we'll go through a few examples. If the examiner raises either a name or a descriptiveness objection, they will also raise a distinctiveness objection. Such an ancillary objection can typically be overcome by overcoming the primary objection. Geographic locations are another example of something that's considered not to have any distinctiveness. And the office takes the position that this is the case even if the place is not known for those goods or services. Generic designs is another example, and in the manual, The example provided is an ordinary representation of grapes and vine leaves. This would not be considered distinctiveness for use in association with wine. Similarly, names of colors, if the associated goods would normally be that color. So for example, the color white would not be distinctive in association with the goods paper. And a final example for today, combinations of independently unregisterable elements. For example, combinations of surnames, descriptive terms, or laudatory terms. So a mark like Joe's Bananas or Best Carrots. It is important to remember, however, that this is not an exhaustive list, and a mark might receive an objection from an examiner, even if it does not fall in one of these categories. Next slide, please, Kwan. So what can you do? To overcome a distinctiveness objection, an applicant can file a written response arguing that the mark possesses at least some inherent distinctiveness. For example, it might be a good idea to remind the examiner that of the distinction between a mark having no inherent distinctiveness and a mark having low inherent distinctiveness. When you consider the fact that distinctiveness is a spectrum, the threshold for some distinctiveness is actually quite low. Another thing to consider is whether the examiner has dissected the applied for trademark and considered each element in isolation. It's a general principle of trademark law that marks must always be considered as a whole. And this is the case in the context of confusion, descriptiveness, and also distinctiveness. While the individual components of a mark might lack distinctiveness, the applied for trademark, when properly considered as a whole, might meet the required threshold. And similarly, if one portion of a mark is distinctive, then the mark as a whole should be registrable. Based on our experience over the past 3 years, arguments against distinctiveness objections have had mixed results. But with 3 years of experience does come improvements as both sides, the Trademarks Office and practitioners, learn to adapt to the new law. An alternative option if you're facing a distinctiveness objection is to file evidence demonstrating that the trademark has acquired distinctiveness, also known as secondary meaning in Canada. To establish acquired distinctiveness, it's necessary to file evidence of use and advertising of the applied for trademark in Canada prior to the filing date of the application. There is no defined threshold as to what evidence will be sufficient to establish distinctiveness, as this is entirely within the examiner's discretion. Nevertheless, a minimum number of a few years and significant sales in Canada is typically required. Establishing acquired distinctiveness is not a viable option for applications that were filed without any use of the mark in Canada at the time of filing. So it's important to remember to consider distinctiveness when developing a filing strategy. Applicants must weigh the pros and cons of either obtaining an early filing date or delaying the filing in order to wait for substantial use of the mark to occur first. Considering the distinctiveness of a proposed trademark early also allows for alternative strategies. For example, filing for a composite mark that contains a distinctive design element or house mark. Finally, as a quick reminder, oh, I'm sorry, Kwan, can you actually, oh no, this is the right slide, sorry. The final reminder and the final part of this topic is that unlike the United States, Canada has only a single trademarks register, the equivalent of the US principal register. There is no Canadian equivalent to the US supplemental register, which provides limited protection to marks that are unregisterable, but that are in use and may over time become an indicator of source. So in conclusion, while the amendments to the trademarks law in Canada have certainly made it more difficult to register inherently weak marks in Canada, there are options available to applicants. So I will pass it over to Kwan for the next topic.
Thanks very much, Tierney. So I'll now move on to a brief discussion about the topic of use. which I know from experience has been a source of questions and some uncertainty from our friends around the world, owing to some of the changes to the Canadian trademark regime over the past few years. So use of a trademark is not required at filing, and that's been the case in Canada since June 2019, when the changes to the law in trademarks here came into effect. And so now when an application is filed, information about the status of the mark, for example, in the past, you would indicate that the mark was filed on the basis of use in Canada since X date, or you would indicate that the application is based on proposed use or intent to use of the mark in Canada. That's no longer required at the filing of an application. And in fact, expanding on that a little bit, there's no filing basis required at all. In the past, you'd have to state whether you're filing based on use of the mark or proposed use, or based on foreign use and registration of the mark. None of that is required anymore now. When you file an application, all you do is you identify the mark, you identify the applicant, you identify the goods and services, and away you go. So there's much less that's required to file an application now in Canada, and certainly no need to provide any kind of information about use. And indeed, even if the applicant wanted to provide use, for instance, if there was use of the mark in Canada and that use went back many years and the applicant wanted to make reference to that in the application, that's not actually possible. There just isn't a way to do that. And as we'll discuss in a little bit, use is certainly still very important, and it's important to keep records and information about that. But purely when it comes to submitting an application, it's not possible to include that information, and it's certainly not required to include that information at filing. Use is also not required in order to obtain a registration for a trademark since 2019. As some of you might recall, before 2019 or before June 2019, in order to obtain a registration for a trademark in Canada, you had to either have use of the mark in Canada, and at that point, the applicant would file a declaration of use for the mark in Canada, and that would be submitted to the Trademarks Office, after which registration would be granted. Or alternatively, the other basis would be to say, there's been use and registration of that mark outside of Canada, and on that basis, dear registrar, please permit registration of the mark in Canada. So if you had one of those two bases, both of which would involve use of the mark, then you could obtain the registration in Canada. Now, after the change in the law, applications that have made it past the opposition period will automatically be registered without the need to assert use or to file a declaration of use. So really, you don't need to have use of the mark in order to obtain a registration in Canada. And that's certainly something that's relevant and worth keeping in mind for you or for your clients, where there is no use, but you're considering Canada as a place for registration. It's important to bear in mind that you don't have to have that use before going ahead with the filing. And indeed, as some of you know, it takes a pretty long time right now to obtain a registration in Canada, unless you're qualified for one of the accelerated or indeed expedited examination standards. Otherwise, the delay is quite long. So it doesn't really make sense to say, let's wait till there's use of the mark. It makes more sense to file the application, get in the queue, get in the process, and eventually get that registration, even though there's no use of the mark at the time of filing. Use of a mark is also not necessary to renew a registration. So with the change in the law in Canada, you may recall, some of you, that registration terms used to be 15 years in Canada, and we were one of the last to change to the more standard 10 years. That is the case now in Canada as well. And in order to renew a registration, I know that for many of our friends in the United States, they're used to the process where you have to file specimens showing use of the mark and a declaration. In Canada, you don't need to do that in order to renew a registration. At 10 years past registration, all that needs to be done is payment of the renewal fee, and that's it. There's no need to file any kind of specimens, provide any kind of declaration. There's no need to prove that there is use of the mark. And in fact, in Canada, At no time will it be necessary to file proof of use of the mark with the Registrar of Trademarks unless the registration is attacked for non-use of the mark. And we'll get into that in a little bit, but that would be the only time when you'd have to file proof of use of the mark before the Trademarks Office. So despite everything that I've mentioned so far, use is still an important and critical part of Canadian trademark law. We're not becoming a first to file country. I know there's certain jurisdictions where first to file is the way that the system works, but in Canada we're still a use-based jurisdiction, and use is still extremely important and remains an important consideration for determining entitlement to a mark. For example, in considering the priority of rights between parties, in oppositions and cancellation proceedings, especially in oppositions, it is certainly possible to ground an opposition on previous use of the mark. That doesn't change. And so use remains critically important. And of course, when it comes to enforcing a trademark against third parties, use is as important as it ever was. So in a nutshell, use is not going away. Use is not going anywhere. It's simply been taken away from the registration process in terms of it not being required in order to obtain a registration or renew a registration in Canada. So I'll just conclude this portion of our presentation by briefly discussing some of the risks and pitfalls of having no use of a trademark. So as I mentioned, it is possible in Canada to initiate non-use summary cancellation proceedings before the Trademarks Office. And when that happens, the registrar will issue a notice which calls for the owner of the application to file proof of use of the mark in association with all the registered goods and services. And that can be initiated anytime after 3 years from registration. So if that happens, then it does become necessary for the registered owner to file proof of use or provide acceptable reasons justifying the absence of use. And if no use is shown or demonstrated by way of evidence, or if the reasons explaining the absence of use are not acceptable, then the registration will be expunged in whole or in part, depending on whether there might have been some use that was shown for the registered goods and services. Another risk is that it may be possible for a third party to apply to the federal court to invalidate a registration. And that doesn't have to be after 3 years. That can take place at any point on the basis that the mark lacks distinctiveness in Canada. And that can arise if there is no use of the mark in Canada. There'd be no distinctiveness, and it could be possible for a third party to move at the federal court to have registration struck. And the last point is, if there's no use of the trademark in Canada and no distinctiveness, it can be very difficult to enforce that trademark. And I know there have been considerations in terms of legislation to enact some kind of change which requires a party seeking to enforce a trademark to actually have used the mark in Canada. I'm not entirely sure where we are in terms of that change from the legislative perspective, but certainly we know that if you're not using a mark in Canada, it'll be awfully difficult to enforce it against a third party. And if you have a registration that you're trying to enforce against someone and you don't have use of that mark, then that is inviting trouble in the form of a non-use cancellation proceeding. And we've seen that happen before. So certainly when looking to enforce, it's important to bear in mind the issue of use and whether there's been use of the mark in Canada. And if not, then it may be worth reconsidering going on the offensive at that time. So I'll now turn it over to Tierney again to talk about goods and services.
Thanks, Juan. So the next topic, as Juan mentioned, is goods and services, and specifically how to describe your goods and services in a Canadian trademark application. So if you could go to the next slide, please, Juan. Unlike some jurisdictions, Canada is relatively demanding, and the degree of specificity required in a statement of goods and services is quite high as compared to many other countries. In fact, by far the most common objection raised by Canadian examiners is that a description is not sufficiently specific. The requirements for describing goods and services in Canadian trademark applications are set out in the Trademarks Act and the corresponding regulations and are also shown here on the slide. According to paragraph 32A of the Canadian Trademarks Act, an application must contain a statement in ordinary commercial terms of the goods and services in association with which the applied for trademark is used or proposed to be used. And according to Canadian trademark practice, a description is considered to be in ordinary commercial terms where research discloses that similar language and scope has been used by others in the same industry to describe the same goods and services. Section 29 of the Canadian Trademarks Regulations further specifies that the statement must describe each of those goods or services in a manner that identifies a specific good or service. Next slide, please, Kwan. So to illustrate the meaning of these requirements, it's sometimes easiest to start with examples of what isn't allowed. So for example, registered trademarks cannot be included in a description of goods or services. So terms like onesies, teleshopping, and carry-on are registered trademarks in Canada. So these cannot be included to describe your goods or services. Nice class headings are also not allowed. So for example, the class heading for class 25 is clothing, footwear, headwear. But each of these terms would require further specification in order to be included in a Canadian application. Indefinite terms such as and the like, and similar, including, related to, and featuring are also not allowed. If you need to describe your specification with further specificity, you need to use definite terms. So something like namely, consisting of, or specifically. And finally, two specific examples that we often come across. First, the terms computer software or computer programs are not acceptable. The specific function of the computer software must be provided, and if it's not obvious from that function, the specific field of use must also be provided. And second, goods that are described as preparations, remedies, or supplements in the context of pharmaceutical, veterinary, or medicinal use are also not sufficiently specific. Such goods must be specified in further detail by specifying the disease, the group or type of disease, disorder, or condition to be treated, or by indicating the specific type of drug or medication. Next slide, please, Kwan. So when looking to file a new application in Canada, applicants are faced with a balancing act between the desire to obtain the broadest scope of protection possible with the requirement to describe the goods and services in specific and ordinary commercial terms. So what can you do? While it's a good starting point, a description that has been accepted in the United States or another jurisdiction might not be considered sufficiently specific in Canada. One available resource is the Goods and Services Manual. This is a free and living document managed by the Canadian Trademarks Office, and it's available online. It lists terms that have been pre-approved by the office. So if you select a term from the manual and include it in your application, it will be accepted by the office without further specification. However, simply because a term is not included in the manual does not mean that it ultimately will not be accepted. In fact, the terms in the manual can also be used to indicate, by analogy, the kinds of terms that would also be considered acceptable to describe a similar good or service. In general, a term is considered acceptable if it's as specific as or more specific than a related or similar listing. And it is important to note that there are limitations to the manual. It is far from exhaustive. Many applicants will not be able to rely exclusively on the terms that have been pre-approved. The manual features few terms used in emerging or technological industries. So for example, in areas like cryptocurrency, artificial intelligence, and non-fungible tokens, the options for acceptable terms are extremely limited. However, as I mentioned, the manual is a living document, and the Trademarks Office is updating the manual to add new terms. In fact, the office has recently commenced a new initiative whereby it's accepting recommendations for terms that should be added to the manual. And this can be a particularly helpful resource where applicants plan to use the same description for a large number of applications, and it can provide certainty that those applications, the description in those applications, will be approved. Another option when you're crafting your description is to review the Canadian Trademarks database and make reference to terms used in other recently allowed and registered marks. However, we recommend this strategy using it with caution because examiners are permitted to exercise their discretion as to whether a term is acceptable or not, and are not bound by decisions that may have been made in the past. But taking these steps and involving a Canadian trademark agent early can help to avoid objections that would unduly delay registration. And speaking of delays, another benefit of consulting the Goods and Services Manual is the availability of expedited examination. As I'm sure many of you know, the Trademarks Office is currently significantly backlogged in Canada, with examination taking place more than 38 months after filing. But when all the goods and services contained in an application are listed in the Goods and Services Manual, examination is automatically fast-tracked without the need for an explicit request. And according to current statistics, in such cases, the application is examined in roughly 22 months from filing instead of 41 months from filing. It's important to note that this option is only available for national applications and is not available for Canadian designations of international registrations. And finally, I'd like to discuss a recent initiative by the Trademarks to address this examination backlog. The office is currently conducting an automated pre-examination assessment of all applications to determine if the goods or services comply with the manual. If they do not, the office is sending a pre-assessment letter to notify the applicant. There is no deadline or requirement to respond to these letters. However, if you amend the goods or services so that they do comply with the manual, examination will be fast-tracked from the time of amendment. So if it is possible for you to use terms only from the manual, there is a clear benefit to doing so. According to the office, 70% of applications whose goods or services comply with the manual proceed to approval without the issuance of any examiner's report. So it can significantly increase the time to register or decrease the time to registration. So with that, I will pass it back over to Kwan for the final topic.
Thanks, Tierney. Okay, so moving along to prohibited marks, which I believe are the most unique and distinctive part of today's presentation. It's something that's truly unique. And in fact, I'm not aware of any other jurisdiction where anything like prohibited marks, or as they're perhaps more commonly known as official marks, are in play. And so prohibited marks typically refer to official marks, which are the type of this mark that can be owned by Canadian public authorities. They also cover university marks, and those can be owned, we know, by US and Canadian and foreign universities. There's also a third branch. I'll get to that in the next slide. It doesn't come up very often, but just for the sake of completeness, there's a third aspect to prohibited marks. But generally speaking, these are referred to as official marks. You'll hear them referred to as such, although strictly speaking, they should be considered prohibited marks. And so the section of the Trademarks Act that deals with this is Section 9, and it states that no person shall adopt in connection with a business as a trademark or otherwise any mark consisting of or so nearly resembling as to be likely to be mistaken for. So that's the test of whether something is close enough or not. So it's whether it's consisting of or so nearly resembling as to be likely to be mistaken for. Any badge, crest, emblem, or mark. So the prohibited mark can be a badge, crest, emblem, or mark, and mark is defined. in the Act. Adopted or used by any of Her Majesty's forces as defined in the National Defense Act. So that's that third branch that I made reference to from the previous slide. Doesn't come up too often, but again, for the sake of being complete, that is the third aspect. I personally haven't dealt with a case that has involved that paragraph, but nevertheless, it is there. Paragraph 2 is of any university. So those are the university marks that we've been talking about. And again, that could be a foreign, a US university, or it can be a Canadian university. They can all hold and own these university marks, as we call them. And 3, adopted and used by any public authority in Canada as an official mark for goods and services. So those are the official marks that come up the most often that we generally talk about when we're discussing prohibited marks. It's these official marks that are owned by Canadian public authorities. So we know that they have to be Canadian public authorities, and that was confirmed, I believe, back in 2003 or around then by the courts, where I believe it was the US Postal Service that wanted to assert official marks, and it was determined that no, it has to be Canadian public authorities that can hold these official marks. And so these marks can be extremely powerful. And here are some of the reasons why. So one of the most important considerations is that these official marks, or prohibited marks, pardon me, are not limited to specific goods or services. So unlike regular trademark applications and regular trademarks, which must be for use in association with particular goods or services, a particular field of trade, a registration, and I use that term loosely because technically official marks or prohibited marks are not registered, they're public notices given. But I'll use registered, I may use registered just to refer to the prohibited marks that have already gotten public notice. They're not limited to goods and services. You don't have to submit a list of goods and services when you're seeking to have a prohibited mark issued. Additionally, these kind of marks can be descriptive and they can lack inherent distinctiveness. So Tierney today has discussed at length the issue of inherent distinctiveness and how sometimes you can have trouble registering such marks. Not an issue when it comes to prohibited marks. And finally, it is possible to have public notice given for a prohibited mark, even if it would actually be confusing or resemble or be completely the same as a regular trademark that is already on the register, or for that matter, any other prohibited mark. That's still not going to stand in the way. There isn't examination for that, and it's not an issue in terms of having a prohibited mark placed on the register. Now, you'll notice that there's an asterisk placed next to the end of that third point, and we'll get to that in a few slides, because it's worth keeping in mind that although one can have a prohibited mark issued despite confusion or similarity with a regular trademark, because of a decision back in 2020 from the Federal Court of Appeal, it's still very important to consider whether there may be some kind of infringement with a senior user or registrant of a regular trademark. Having that prohibited mark is no longer, or we now have confirmation that's no longer a bulletproof shield against infringement, but we'll get to that in a little bit. So a prohibited mark can form the basis of an objection against a trademark application, a regular trademark application that was filed afterwards, after the prohibited mark had been given public notice. And if that happens, typically the regular trademark holder will require the consent of the official mark owner in order to overcome the objection. Now, if there are differences between the official mark or prohibited mark and the regular trademark, it is possible to file submissions with the Trademarks Office in an attempt to overcome the objection. But if the marks are identical, or if those submissions are rejected, then it will be necessary to have consent of the prohibited mark owner to overcome the objection. And it is entirely at the discretion of the prohibited mark owner whether to provide that consent or not. There's nothing that can compel them to provide consent. And indeed, if consent isn't given, then that would act as an absolute block against the registration of a regular trademark. So again, another real source of power for a prohibited mark owner in order to control the kind of marks that are on the register If there's a regular trademark application that comes around that is the same as or similar to that prohibited mark, and if the prohibited mark owner feels we don't want to provide consent for whatever reason, then that would be a block and prevent registration of the regular trademark. And also, a prohibited mark can form the basis of an opposition against a regular trademark application. There's a ground of opposition that is based on similarity or resemblance to a prohibited mark. So again, another way for prohibited mark owners to exercise power that is available to them. So now that you've heard how powerful these prohibited marks can be, I'll get into a very brief discussion about it's the application process to get public notice of a prohibited mark to be issued on the register. So there's no substantive examination required for prohibited marks. There's no assessment of confusion, no assessment of descriptiveness, as I mentioned. And in fact, in contrast to how long it takes to have a regular trademark application examined, prosecution and review of a prohibited mark usually takes only about 4 to 6 months. I think it might be a bit closer to maybe 6 to 8 months these days, but still a much shorter time than with a regular trademark application. Now, in order to have public notice given for a prohibited mark, there is a requirement for adoption and use of the prohibited mark, and that's required before filing. But it's a very simple and easy standard to meet insofar as a printout from a website or from a brochure, from promotional material. That's all that's required, and that gets submitted to the trademarks office, and that's really all they're looking for in terms of adoption and use. The other issue here is that the public authority, if this is an official mark, or the university, in the case of a university mark, has to establish that they are in fact a public authority or a university. With universities, it tends to be a bit less controversial, but with public authorities, sometimes there is some question about whether that entity is in fact a public authority. And what the trademarks office is looking for is some kind of legislation that establishes the public authority, or in some cases, the university. In terms of maintaining a prohibited mark or having it removed, once the public notice of the prohibited mark is given, it will be on the register. So that is akin to registration of the prohibited mark. Of note, prohibited marks don't expire and they don't require renewal. Once they're on the register, they stay there, and they can only be removed by application to the federal court, or if the owner decides that they want to voluntarily withdraw the prohibited mark, they can write to the trademarks office to do that. And I know personally that in some cases, that power to provide consent and control what marks get on the register sometimes actually becomes too troublesome or too time consuming for the owner of that official mark or prohibited mark. And I've come across cases where the owner of the mark will actually say, you know, we don't want to have to deal with all these requests for consent from time to time. And this mark perhaps isn't as important to us as it once was. We're actually going to write to the trademarks office and just voluntarily withdraw the prohibited mark, because that would remove the need for later trademark applicants to request consent. But that is really, that and application to the court is the only way to have a prohibited mark removed. There's just no need to renew them, and they don't expire. So I'll conclude just by talking about ways in which some of the power that is vested in these prohibited marks is slowly kind of being chipped away. So we know that there are some legislative changes on the horizon that are going to make it easier for the office to get rid of prohibited marks. So it'll be possible to make submissions to the office that a public authority no longer exists, or that the entity that owns that that prohibited mark is not a public authority, which means that it wouldn't satisfy that third leg earlier that we're talking about in terms of being a public authority. And so it will be easier to do that. But in reality, we're already seeing some of that come into play. The Trademarks Examination Manual mentions that it is possible, if there is an objection based on a prohibited mark, to have that objection removed by submitting evidence to the registrar that the public authority no longer exists. And personally, I've worked on one of these files over the past month, where we found evidence that the public authority no longer exists. And we submitted that evidence. We're waiting for the decision from the Trademarks Office, but I suspect, based on my reading of what's in the Trademarks Examination Manual, that will be sufficient to have that objection removed. So we're already starting to see these changes that are kind of eroding the rights and power that are in prohibited marks. And moving along on that point, and you'll see that asterisk that I referred to a few minutes ago. This is a decision from 2020 of the Federal Court of Appeal, and I won't get into the details of it, but the take-home point here from this decision is that a prohibited mark is not an automatic defense to infringement of a previously used and registered trademark. So in this case, the public authority went and obtained public notice of an official mark and took the position that because of that, they were immune to a claim of infringement of a previously registered mark and previously used mark by the owner of a regular trademark. And that went to the federal court and ultimately on appeal to the Federal Court of Appeal. And the court clarified that no, just because public authority, you went and got this prohibited mark doesn't mean that you can just wantonly go out and just take over the regular trademarks of other parties when they already have registrations and have used those marks. This just simply isn't a way for public authorities to just supersede those rights. Now, one thing to bear in mind is that timing is important. And I think the result here would have been different if public notice of the prohibited mark came before use and registration. If that was the case, then Section 9 of the Act, which I discussed earlier, would come into play and it would prevent the regular trademark owner from being able to make that claim. So that brings us to the end of our presentation section today, and I see that we've got a good number of questions coming in. So we'll now take a look at some of these. As a reminder, if you have questions, feel free to submit them through the Q&A panel by clicking on the button at the bottom of your screen. And so just give us a moment here while we take a look at the questions. There's actually quite a few of them, and we'll start answering some of these.
I've been monitoring as you've been finishing your topic. So there is a question I can kick off the answer period with. It's about goods and services. So someone mentions that the pre-assessment letters that are going out do not identify which descriptions are not compliant. And what should you do? And I think that's a great question and a great point. So these pre-assessment letters are completely automated. The Trademarks Office is doing a review of all applications, computerized review, and determining either yes, the goods and services are compliant with the manual, or no, they are not, and then sending out the letters. So if you get a letter that says it's not compliant, it's merely an FYI. There is no indication of which terms in your application may or may not be compliant. So it puts the burden on you of identifying those terms. So you will need to either yourself or ask your Canadian trademark agent for assistance to look at the application and the terms included therein and compare them to the terms in the manual to identify which ones are compliant or not, and then revise accordingly.
Thanks, Tierney. So I'm going through the list, and I guess I'll pick another question. We've got quite a few to pick from here, and certainly if we don't get to your question today, we apologize. We do have a cutoff in about 10 minutes or so, but certainly we're happy to follow up by email. And so I'll take another question from my section here, and this is an interesting one, and I can't say that I can provide a definite answer, but I'll take the question. And so the question is, how different does a mark have to be from a prohibited mark to overcome the objection? So really, you're looking at the degree of resemblance. There's no consideration of whether or not they're in different fields or not. It really is just looking at the marks one next to the other and saying, how much do they resemble each other? And I appreciate there's no definite answer to that, but you're looking for just ways to distinguish between them. And there's some case law which says that you don't really need to have that much of a difference. Arguably, the amount of difference between the marks might be less than in a confusion assessment. So you're looking at something that's closer than confusion, but it really depends on a case-by-case basis. And really, again, the point you're looking at is the degree of resemblance between the marks. And you do take into consideration the appearance of the marks, the way they're sounded, the idea suggested. So the factors that do go into the degree of resemblance for confusion. But ultimately, you're really just trying to look at the two marks and say, does this resemble the other one? And if the answer is yes, then I think they're too similar. Again, it is subjective. I don't think there's an objective standard other than referring to the resemblance test. But that's my best attempt to answer that question.
So there is another question about the goods and services, and this is actually about expedited examination. So someone mentions 22 months to examination. Is that really fast tracked? And yes, that is the correct timing. I believe as of this week, it's 41 months to examination for a regular turnaround. And when the goods and services are in the manual, it's automatically fast tracked to approximately 22 months. And this person is also asking, why is it taking so long? And is there a particular reason? There are a number of reasons to our understanding, as we've been told by the Trademarks Office, both as a result of the COVID pandemic that significantly impacted the timing. As many of you, I'm sure, know, the Trademarks Office in Canada is not electronic and was not set up electronically before the pandemic. Everything was still managed by paper. So that caused a significant delay, as well as turnovers as a result of the pandemic. And also adapting to the law, which is now 3 years old, but there were a number of changes that we had to implement. So those are the reasons. And I also just want to mention briefly, it's not really a subject of our talk today, but there are other options available for expediting your application, which take even more time off. So I believe it's examined within even a couple of weeks or a month. And these are cases where, for example, you need the registration because you intend to initiate litigation to protect your rights. So you need to formalize a registration. And there are a number of other cases out there. I believe we have some articles on that subject. So if expedited examination is really important to you, you can check those out as well.
Okay, so I will take another question from the list from my section. So we have an attendee asking, is non-use cancellation query issued automatically after 3 years, or is there random selection of 3-year-old registrations to test for use? And the answer to that question is actually neither. So there's no selection or automatic query of use. There has to be a third party that is interested in seeing if there's use of the mark, and they write to the Trademarks Office to initiate that notice. And then the Trademarks Office issues the notice calling for proof of use of the mark to be filed. So if there's no party that requests that, then the proceedings are never initiated. And so it's not automatic, and there's no random selection.
Okay, another question that I have, again, on those pre-assessment letters is whether what happens if you do not respond to those letters. So as I mentioned, there is no deadline or requirement to respond. The letters are merely an FYI. If you do choose to file an amended application to put your goods and services in compliance with the manual, it will be automatically fast-tracked. If you do nothing, nothing happens. The mark or the application will simply be examined on a regular turnaround. So as I mentioned, right now at around 41 months from filing, and it will be the same process as normal. So you will either receive an examiner's report if there are any objections, whether technical or substantive or otherwise, or you will receive an approval notice.
Great. Okay, I think we have time for maybe one or two last questions before we should wrap up for today. So this is more of a comment, I guess, and I've been advised by an attendee that there is in fact a corresponding prohibition of marks in the US TM statute. So that's very interesting, and thank you for sharing that. I have another question here. Are prohibited marks referred to as well-known marks in other jurisdictions as well as supermarks? And I believe this attendee kind of answered their question, because I also see that they then said, so prohibited marks are not akin to well-known marks. And I just wanted to clarify that point. That's correct. There's no relationship between whether a prohibited mark is well-known or not. It's not a requirement. They're different things. Really, prohibited marks are just an avenue for Canadian public authorities and universities to obtain public notice of a mark that goes on the register and which can exclude other parties from using and registering similar marks that come after the public notice of the prohibited mark. There's no requirement that the prohibited mark be well-known, famous, as long as it's been adopted and used. That's the only requirement. So there's no condition of fame or recognition at all. Tierney, I think you can probably pick one more question, and I think we should wrap it up for today.
I'm not sure there are any more questions on my section, at least not ones that I currently know the answers to. So I think if you have another one that you think would be beneficial to answer, you can take the last question.
Absolutely. Let me just go through here.
It looks like prohibited marks were a very hot topic.
I think so, and I thought it might be. So the last one I'll deal with then is what party has the right to apply for and register a prohibited mark, and I appreciate that's taking kind of an easy way out, because I think I discussed that during the presentation. So for university marks, it would be a university, Canadian or foreign. And for an official mark, it has to be a Canadian public authority. So Crown corporations, just to give an example, Canada Post would be the kind of entity that has the right to obtain and register a prohibited mark. So that's it for today. We've reached the end of our scheduled time, and we'll be wrapping up here. If your question was not addressed, please accept our apologies, and please reach out to us directly by email. We're happy to try and provide answers that way. As a reminder, please do complete the survey when the link pops up at the end of the webinar. We certainly appreciate your feedback of all types. And finally, thank you very much for taking time from your day to join us. And hopefully we'll see you in September for the start of our fall trademark webinar series. More information on the fall series will follow by email. For now, have a wonderful rest of your day and enjoy the summer.